Let me know when you're ready for me to switch it over to presentation.
Ready. Good morning. First off, on behalf of my client and myself, thank you. You paid attention. And you agreed to become a part of something that you don't come across every day of your life. Okay? Probably inconvenient. And I'm sure all of you would much rather be someplace else right now. And on top of that, we're going to ask you to make a really important decision. So thank you. I told you in my opening statement that everything that the police department and frankly prosecutors knew about what happened to Polina Wright came from what Dale said to them. But all they seemed to hear was we were pointing the guns at each other. A statement made minutes after the worst moment in his life, covered in his girlfriend's blood, while his head is swirling between grief, anger at himself, and disbelief for the situation he found himself in. A couple hours later, when Detective Kern went straight to that statement, Dale said, no, not pointing at each other, pointing in the general direction. And it's on the tape. Watch it. Okay? The pointing at each other thing should have died a quick death right there. Because he explained, no, that's not what we were doing. He has never, ever said we were pointing guns like this, aiming at each other. There is absolutely no evidence that that ever happened. But apparently, Detective Kern didn't hear the air come out of the balloon when Dale said, no, we weren't pointing them at each other. They were in the general direction. Because obviously they're sitting across the table from each other. That suddenly didn't matter. No. Apparently,
we're going to pause the defense closing arguments. You're going to see them all in full as we get into our next hour. Let's back the truck up just a moment and get some insight and analysis on the state's close. Remember, the state of Florida is who carries the burden here. Let's bring in prosecuting attorney Anton Bell. Anton, what do you think? Give us your assessment, please, of the state's close.
I love the theme: intentional acts, unintentional consequences, or results. And so I love the theme. I love the fact that he was very methodical and talking about each intentional act that was committed by this particular defendant. And here's the thing. I say this particular defendant because he is someone who is not your normal citizen. He is someone who is trained yearly concerning firearms. He is someone who is taught concerning safety of firearms such as the one that was used to kill this young lady. In addition to that, he is someone with that particular experience who pointed a firearm that he knew could have been loaded, and he discharged that firearm. And I love also what the prosecutor said about you can leave a whole lot of stuff out of the courtroom when you come into this courtroom, but you don't have to leave your common sense behind. And so if you're pointing a firearm at a wall, you're not going to hit someone dead square in their forehead in between their eyes. No, you have to actually have been pointing that firearm at that individual and at that target. And you're taught whenever you are using a firearm, only point at your target. And he hit his target.
Exactly right, Anton. I couldn't agree with you more. Tell me, it was a fast trial, as we know. Do you think it's going to be a fast verdict, too?
I do. Because I think that when you put your common sense together and you think about the fact that he hit her square in between her eyes and her forehead, it doesn't take a rocket scientist to help you to understand he was pointing that firearm at her.
I agree. Anton Bell, so great having you on the show. Thank you very much for everything this morning. And thank you at home for being with us. We're going to hit a break. You'll see the rest of the defense closing arguments next. You.
Welcome back to Court TV Live. Good to be with you on this Wednesday morning. We're in Florida watching the closing arguments in this case involving a former sheriff's deputy accused of fatally shooting his girlfriend. Defendant Leslie Boileau took the stand earlier this morning, and he admitted he pointed the gun, the big gun, at his girlfriend. 25-year-old Polina Wright pulled the trigger, but he claims he didn't realize the gun was loaded. That makes sense. Boileau faces up to 30 years if found guilty. But why was she naked? Why did her finger get hit? Was she defending herself? What was really going on here? Was he really aiming at a mirror, or was he aiming at her face? Hit her right between the eyes. We'll see what the jury believes. Let's go back now into the courtroom. The defense closing argument. Let's watch.
No. Apparently, the detective decided he knew all that he needed to know. Didn't matter what happened earlier that day. He told me that when I asked him if he knew what they had done all day. Didn't matter. That it would have mattered if Dale and Paulina had had some argument and he threatened her. But the detective didn't need to know that, apparently. It didn't matter what Dale and Paulina did for the 2.5 hours after they got home from the restaurant. He told me that too when I asked him. Do you know everything they did when they got home? I know enough. So obviously, they weren't sitting there with those guns for 2.5 hours. That defies any logic. They were getting up, going to the bathroom, going to see the TV. There's a dog in the house, there's a cat in the house. But that didn't matter to Detective Kirk. Didn't matter how much alcohol is in a $4.49 margarita. It didn't matter whether there was more alcohol in the house. Which is why he said he didn't ask the evidence technician to look for it. There wasn't, and you could see it in the pictures. Look at the picture of the dining room table. The only can on the table, the evidence technician identified as green tea. There's pictures of the kitchen, sink. There's no alcohol container anywhere out in the living area of the house. That wasn't important. But he kind of tricked himself, because his explanation for not telling the tech to look for alcohol was, well, I talked to him and I didn't see any indication of a problem. Boom. But why are we talking about alcohol today? Why? Detective Kern didn't think it was a problem. And that is absolutely symptomatic of how the detective approached this case. He reached conclusions based on little nuggets of information, selective nuggets of information, and then decided there was no need to actually test or verify those conclusions when it could have been done so easily. Show me what you did. That's not a technical or hard question. Pretty easy. And when a guy says we were pointing the guns at each other and then says no in the general direction, how do you figure that out? Show me what you did. Did he ever ask him? No. Not once. Not one time. Because he'd already made up his mind. And that's why, ultimately, he never really bothered to find out the circumstances surrounding Polina's death. He shot him with a gun, and he should have known better because he was a cop. Right, and he tried to backtrack from that, but he sure wrote it in his report. He didn't bother to ask. But now you know what happened. Because in this room, with his freedom at stake, every question is worth asking. Even yours. And I used to hate jury questions. Just scared the crap out of me. But I am thrilled that you folks got to ask questions. Because you did what Kern did. And he is totally incapable of telling you what happened to Polina. Because he doesn't know. So at the point they sat down, having rested their case, you didn't know. All you knew was she was shot in the head. And you knew, because of listening to his anguish, that he was responsible for that. You knew that. But that doesn't make him guilty of manslaughter. And I'm going to talk about this in a minute, but the problem is that manslaughter is not a function of the consequence of someone's behavior. You look at what they did, not the result of what they did. There's nowhere in that instruction that tells you somebody's guilty of manslaughter by culpable negligence. Culpable negligence comes along when you do something really bad. No, it doesn't say that. It focuses on the conduct. Is what he did more than making a mistake? And we'll put the consequence over here for a minute. Okay? Keep that kind of in the back of your head. And we're going to go through that instruction. Mr. O'Neill went through it one time. I'll focus on what I think you need to see. But all the law comes from the judge, and you're going to have it, so you can read it. Everything I said in an opening statement that would be revealed by the evidence proved to be accurate. I didn't miss one thing. But only because I presented evidence and because I poked or prodded evidence out of their witnesses. The evidence bringers failed. Utterly failed. What happened to 25-year-old Polina Wright was a tragedy. It shouldn't have happened. It makes you angry. Makes me angry that a mistake took the life of a beautiful young woman. But you can't use anger. You gotta leave that one outside. And the judge is gonna tell you that. The next instruction he's gonna read to you says, this case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. Okay? Is it wrong to be angry? Of course not. Of course not. But that doesn't make it a crime because it makes you angry. And to illustrate that, let's take a step back. Think for just a minute. And for a moment, let's pretend there was no gun. Okay? Let's pretend that on the way home from the restaurant, Dale dropped his phone on the floorboard of the truck. And for a split second, he looked down and shifted his feet to see where the phone went and slightly turned the wheel. Truck ran off the road, hit a tree. Pauline is dead. Would you be any less angry about the tragedy of her death? No. But under those circumstances, what caused her death was something probably every one of us has done one time or another driving a car. Made a stupid decision. Does that make you guilty of a manslaughter under my little facts? No. That's the differentiation. Driving cars is dangerous, handling firearms is dangerous, and accidents can happen doing either one with devastating consequences. But the consequence is not what makes it a crime. And it is to the law that we must look to determine whether a crime was committed in this case. You've seen this. There are two elements. We know Pauline is dead. He knows it his every waking moment. So we got two ways to do it. Intentionally committed an act or acts that cause the death of Polina Wright. Or cause the death of Polina Wright by his culpable negligence. So what was the intentional act? Pulling the trigger? He said he didn't intend the weapon to be pointed at Pauline. The only question Mr. O'Neill extracted from him was confirmed that you intended to pull the trigger. He said yes, he was doing a function test. He was.
All right, we're going to slip in a commercial break. You see the clock on your screen. There's a court-imposed delay in us broadcasting, so we're a little bit behind. The jury is now in the case is now in the jury's hands. We'll monitor that. Our team will tell us if there's a question or a verdict. Of course, we can show the verdict live according to the court rules. We just had to delay a little bit of the closing arguments and the rest of the testimony. So let's get a break. We'll pick up the rest of the defense close, and we're on verdict watch in this case out of the state of Florida. Leslie Boileau, stay with us.
I'm Vinny Politan. Welcome to Closing Arguments.
What's happening here?
It's unreal. Let me show you exactly what happened.
Closing Arguments with Vinny Politan, tonight at 8/7 Central, only on Court TV.
4 dead students.
None of it seemed to make any sense.
He was evil.
What devastation.
All I can do is scream.
Victim to Verdict with Ted Rowlands. New episode Saturday night, 8 Eastern and Pacific.
Only on Court TV.
And in fact, there's general rules of safety that you guys learn every year. Like you always treat a firearm if it's loaded.
Correct.
And you never point it towards another person.
Correct.
And that you should not handle firearms, especially when drinking or intoxicated.
Yes.
And that you only point a firearm as something that you intend to kill or destroy.
That's correct.
Basic gun safety procedures a sheriff deputy should know and follow. But Leslie Boileau took the stand earlier today where you saw right there, he admitted he drank the night that he fired that gun and killed his girlfriend. He says he simply was trying to clean the gun and didn't realize it was loaded when he fatally shot her. That was his story on the stand. That's what he's sticking with. She was nude and was hit right between the eyes with her finger also hit, as if possibly you could opine was saying, don't point that at me. The defense has their opportunity, one last opportunity, we're watching it now, to convince this jury not to convict him. You see the clock on your screen. They have the case. We're a little behind because of the judge's order in this case. We had a delay imposed. So let's go back in and listen to the defense very closely to see what kind of thread they're trying to get a thread through a needle here, because this is a very tight window and they're trying to go through it. Let's listen.
He was doing a function test. He wasn't doing a dry fire exercise. Those are two different things. The function test goes with the AR style rifle because of the way it's put together. The dry fire exercise is a basic firearms training technique. It's safe. And what he did with Polina does not demonstrate someone who was completely mindless of being safe with firearms. He handed her the rifle, no ammunition here. All back by him. Handed her, she picks the handgun up and it's loaded. Cool. Let me stop what I'm doing. Got it out of the holster, cleared it out, put the stuff over by him. And you saw the picture of that. The magazine and the one live round that he pulled out of the chamber, right there by him, where she couldn't get it. So she wasn't going to hurt herself or anybody else with what he was showing her. Nothing reckless about that. So what now is the intentional act? Suddenly, a few minutes ago, it becomes intentionally pointing it at Polina. And he did not prove that. There's no evidence of that in this case. The best they can get is, yes, he meant to pull the trigger to finish his function test. He didn't intend for it to go off. He didn't intend for it to have been steered in the direction of Polina because he had turned and was looking at the television. He didn't intend any of that. But yes, he pulled the trigger. But you don't get to manslaughter that way. And it's kind of evident how it morphed from you intentionally pulled the trigger, yes, because that was the honest answer, to now suddenly he's guilty of intentionally pointing the weapon. He never said that. Never said that. And there was no evidence. And, you know, Mr. O'Neill's fascinations about what Mr. Boileau really meant when he was making his statements and inviting you to kind of fill in gaps, like where was her hand? The expert, Dr. Lang, said she couldn't tell you what she was doing with her hand. No way. Okay? But now suddenly, don't point that gun at me. Folks, if that had happened, she'd be alive. Because he'd look up, oh, damn. Whole thing. You wouldn't be here, I wouldn't be here. Dale would be driving his car on patrol. And who gets a gun, put it in their face, and goes like that? But it went in through her finger, back of her finger, and out. She had a lot of hair. And Dr. Lang agreed. She could have been pushing the hair out of her face. Dale doesn't know what she was doing because he wasn't looking at her. And he certainly wasn't pointing the rifle at her. It ended up pointed at her. But it wasn't intentional. And he can't be convicted based on the evidence in this case, based on the argument that he intentionally pointed that rifle at her. There's no evidence of that. So let's bump down to culpable negligence then. Because I submit intentionally pulling the trigger, which is the only thing they proved, does not establish manslaughter in this case. And the instruction is going to tell you that. Every person has a duty to act reasonably toward others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence, period. It's not criminal. Without any conscious intention to harm. Has there been any evidence offered in this case to prove that Dale Boileau consciously intended to harm his girlfriend? And if there isn't any evidence of it.
All right, let's slip in a break. Again, the jury has the case. They've had it for 15 minutes or so, enough to pick a foreperson. They're just starting the deliberation period. Krista Ramey's watching from Los Angeles, trial attorney there. First, let's talk about the defense attacking the investigation, saying that the cops dropped the ball. This is a sheriff's deputy. I mean, it's a little disingenuous to say, because we all know that he's going to get the benefit of the doubt because of his profession, no doubt. And for them to say, well, they didn't, yeah, they didn't ask that because they were helping the dude out, or they thought they were. That's one thing. What about this argument on the defense side that there was no consciousness from the defendant to actually harm? Is that the deal, or is it what the prosecution says is that you put yourself in a position that you knew better and you did something and you did make a conscious decision to do something that you knew could potentially harm?
Yeah, hi, I haven't seen you all. Nice to see you, Ted. Thanks for having me. It's the latter. It's not about him intending to harm her. If he intended to harm her, we'd be talking about probably a second-degree murder charge and not a manslaughter charge. So there's a distinction here. It is when your conduct is so reckless that you knew or should have known the potential for it to cause harm, then we're talking manslaughter. And I don't think that this, to use your analogy from earlier, this needle is not getting thread. I do not believe, because you're not demonstrating how he wasn't doing something reckless. In fact, with every word is being said by the defense attorney in his closing statement, he is helping prove the prosecution's case in its own arguments, because he is talking about each decision that was made that evening and each decision that was recklessly made that evening that led up to this horrible death. And the decision to drink, the decision to clean his gun while drinking, the decision to clean the gun while drinking with his girlfriend, who for some unknown reason is naked. And there's all these unexplained things in between, right? I don't think that this needle has been thread at all by the defense here.
Yeah, it seems more cloudy, but it's not over. Let's get a break. We'll see what the rest of the defense close is before the jury gets the case-ish. They already have the case, but we're a little bit back because of the court order on the delay. So let's watch the rest of the defense. 16 minutes, they've been at it. What will they decide? We'll find out today. Stay with us. All right, before we head back to Florida for the rest of the defense closing argument, quick update on another case we're monitoring very closely here at Court TV, the home invasion murder trial. That's taking place in Michigan. The defendants here, Carlos Hernandez and Joshua Suazu, are charged with unlawful imprisonment and murder in the October 2024 death of 72-year-old Hussein Murray. Prosecutors say that Murray, he owned a pawn and jewelry store, was robbed in a planned robbery gone wrong. It was at the house. Body camera footage of the aftermath of the incident. Take a look at this. Was shown in court this morning. This is an officer releasing Murray's wife, Linda, from duct tape restraints. This is a heartbreaker. After responding to the scene, opening statements, he was dead in the basement, by the way. Opening statements also wrapped up earlier this morning. Take a listen to some of the states.
So as the door opens, up comes Hernandez first. Hernandez now, and you'll see the pictures between the entry exit to the basement is very close to the kitchen. Hernandez is there, and he starts saying, "Where's the cash? Where's the safe? Where's the jewelry?" It's like, "You don't have a safe. I got cash in my purse." It's like, "Where's my husband?" It's like, "Where's the cash? Where's your jewelry? Jewelry's in the safety deposit box. Where's my husband?" And then you'll hear, up comes defendant Zuazo. And now she sees him at close range, and she sees blood on his shirt. And at that point in time, she starts screaming. She starts screaming, "What happened to my husband? Where's my husband?" And Zuazo says to her, "He's sleeping." So this was not random. This was not an accident. This was targeted.
We'll continue to keep an eye on that courtroom. We'll be heading there later this afternoon, giving updates throughout the day. Now, though, Florida. We've been watching this. Deputy shoots the girlfriend trial for defendant Leslie Boileau, the former sheriff's deputy, charged with manslaughter after investigators say he fatally shot his girlfriend, Polina Wright, during what he described as an accidental discharge at his home in Ocala, Florida, while he was cleaning his gun. Right now, we're listening to the defense closing arguments. Let's go back in.
And if there isn't any evidence of that, then stupid stays stupid. It's negligence. It's a mistake. And there are things we can do in this country when someone does something stupid that causes harm to other people. You sue them. But they can't be convicted of a crime for an accident. The defendant cannot be guilty of manslaughter by committing a merely negligent act. There you go. Now the instruction is telling you, oh, so under the circumstances of this case, pulling the trigger doesn't get him to manslaughter. That's why it had to morph into pointing the rifle. And then the judge is going to tell you, in order to convict of manslaughter by act, that's that first one, it is not necessary for the state to prove the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent. And I submit to you, pulling the trigger under the circumstances explained to you was negligent. Here. It wasn't a heinous crime that Mr. O'Neill wants it to be. It's a horrible, horrible accident. Only an intent to commit an act that was not merely negligent. And then he's going to give you a longer definition. I will now define culpable negligence for you. So now we'll bump down to the or B, right? We've finished with the act. They haven't proven that. Now let's talk about whether they've proven culpable negligence. As I have said, every person has a duty to act reasonably toward others. If there is a violation of that duty, without any conscious intention to harm, that violation is negligence. It's the second time that he's going to read that to you. That must mean something. It's there twice. But culpable negligence is more than a failure to use ordinary care for others. For negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard of human life or a grossly careless disregard for the safety and welfare of the public. Okay? Doesn't say anything about consequence. Let's focus on what he did. Is there any evidence that in introducing her to these firearms that he was reckless or careless? No. Everything he handed to her, he made safe. And, oh, but he's got all this training. And you don't train with bullets on the table. And he should have known better. He said that. Okay? And he should have. But the training presents an interesting issue. Okay? That much training with a firearm removes the fear. Okay? I've had some firearm training. They still scare the crap out of me. And you can make a mistake being scared. But when you've had as much training as Dale has had, unfortunately, you get confident that you know what you're doing. And that's a normal consequence of being good at something. Like a chef with a knife.
Ah, the old too much training argument. That's what happened. He lost his fear of weapons because he'd been trained for too long. Let's get a break. When we come back, we'll go back, finish up the defense closing arguments. The jury already has this case. 30 minutes nearly of deliberation. Stay with us.
My
my two best friends were just murdered.
Join me for a Court TV true crime series where we take you from the crime scene to the courtroom.
Donna Adelson hates every piece of grass that Dan Marcel ever walked on.
It's something that'll haunt all of us forever.
It always seemed like he was covering or deceiving.
This was a whole different level.
Victim to Verdict with Ted Rowlands. New episodes Saturday night, 8 Eastern and Pacific.
Only on Court TV.
Welcome back to Court TV Live. We're watching this case out of Florida. It's a short one, just 2 days, and already we're in the closing arguments. A year ago, Ocala, Florida police found Polina Wright dead from a single gunshot wound between the eyes. Her boyfriend, this guy here, Leslie Boileau, who's a sheriff's investigator, told investigators that they went drinking. They each had 3 margaritas at dinner, and he accidentally shot her while he was cleaning his firearms. He's now charged with manslaughter. Cleaning the firearm, shot her right between the eyes. She was naked, and he had his big gun out. Let's go back in. The defense is trying to convince this jury that part of the equation here is that the guy had too much training. Yeah, when you're trained and you're that proficient in firearms, that's when you make mistakes because you're too comfortable. Let's go back in.
I did that 3 days ago. Accidents happen. And you don't decide whether the accident is culpable negligence by looking at the consequence. Nowhere in this instruction do you see that. It doesn't become a crime because something awful happened. You have to look at what they did and what was going on. Without any conscious intention to harm. Second time. And then I read that to you. Grossly careless disregard for the safety and welfare of the public. Nothing about what you heard Dale Boileau did meets that definition. Because then they have to ignore how he handled the weapons when he gave them to her. Right? They want to jump now to this thing where he pointed it at her and pulled the trigger. And there's no evidence to support that. The negligent act or omission must have been committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant knew or reasonably should have known was likely to cause death or great bodily injury. Consciously. He said from jump, he didn't think the gun was loaded. He forgot. And because of the way he kept it, remember what he said, and he told Kern this too. When he puts his gun away, it's got an empty chamber and a loaded magazine. Right? So the function test, which is designed for the AR rifle, because of the complexity of the trigger mechanism, is you pull the trigger, hold it back. The hammer falls, it clicks. And you have to listen for it. They'll explain it. Make sure we got everything in position so the gun will work. And you're holding it back, and then you pull the charge handle out. And it's not spring loaded. It'll go out and it'll stay there. And then you release the trigger, which resets it. Gets all the parts in line so that it'll go again. And you push the rod in. And if you're doing a proper function test, there's no bullets anywhere around you, okay? So when you pull the trigger the second time, it's gonna happen. But unfortunately, this one grabbed around because he forgot that he already had it ready to put away. All right. So there's no evidence of any utter disregard for the safety of others. And there's no evidence that he followed a course of conduct that he knew or should have known was likely to cause death or great bodily injury. Did he mess up? Absolutely. But you can't judge this because of what happened. That's the hard part for you folks. Because it's so easy to become enraged at the whole idea that she's dead. You have to look at what happened. And the only reason you know anything about what happened is because he told you. Nothing in the other evidence introduced by the state tells you anything. And every bit of it corroborated what Dale said. In this country, we tell our citizens something important. If you have an accusation to make it in court, where a group of jurors can bring their experience and common sense to weigh the evidence and apply the law. But how do we protect people from mistakes and unfair accusations? The law has a way. It's called the burden of proof. It is our demand as citizens that any accusation be proved beyond a reasonable doubt. And as the judge has already told you, proof beyond a reasonable doubt does not mean proof beyond all doubt. Okay? So they don't have to prove it beyond all doubt. But a reasonable doubt is not a mere possible doubt, speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, but one which wavers and vacillates, means jumps back and forth, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. That's why, when you come to your decision today, you don't have to guess or speculate or consider mere possibility. I have not asked you to do that. I have given you evidence of what happened to Polina Wright in the absence of the evidence from the state. If the state cannot prove there are no reasons to doubt, nothing that would give a person reason to pause, that would make one hesitate before finding my client guilty, then the jury must keep its promise. Live up to your oath and do what the law requires. In this case, as difficult as this is, as terrible as what happened is terrible, there is no evidence that my client is guilty of manslaughter. He made a mistake. He'd be the object of a wail of a lawsuit, but he's not guilty of a crime. Thank you.
Thank you, counsel.